Welcome back to this third segment of this law session on the common law and its development. Now, before the break, I said as soon as we get back, we would look at the historical aspect, or rather traditional picture, in relation to the development of English law. Well, it all began with the customs of Anglo-Saxon society. Now, customs is said, the custom is said to have had its roots in the life of the people, and really it was about reflecting the social structure of that way of life. Now, the daily conditions of life were indeed rather grim at that time. Now, most of England was covered by dense forests, and the population was, of course, largely illiterate. So, law was more or less local custom, and it was largely unwritten, and it was understood as a set of orally transmitted rules. Now, as a body of rules, their context seems to have been directed at preventing bloodshed by recognizing elementary rights to property and personal freedom, and of course substituting compensation for the rigors of blood feud as revenge for injury. The whole point, it's all coming back from history, where you're looking at persons who are not happy about something come before somebody who is an impartial person, looking at what's happened between the parties and trying to come to some rational conclusion or solution. Now, stating who had what rights to occupy and use land was, of course, a crucial task. Now, in 1066, the Norman French Baron William, of course, defeated the Saxon King Harold at the Battle of Hastings and conquered England, becoming King William I. After the war, local laws slowly gave way to a general law of the country, which became known as the common law. Consequently, what we see is an evolution, and the effects of that were, of course, the introduction of Latin and other official languages of continental Europe. We see a separate ecclesiastical court being set up, dealing with religious matters and people in religious service. So the whole framework of family law, for example, was set up in the context of the ecclesiastical courts. There was also a general principle of landholding, and we again see the whole this whole estate in land and the way that land is being held by tenure and so on, again being developed through this whole system. Now, as communications improved, then so did the spread of central administration, and what you got was a centrally administered or a centrally administered law. The fact that a central body was attempting to develop law as a means of administering the country changed the character of law and legal customs. We see that over time the King's Court became the most important forum for the resolution of disputes between citizens. Now, the law of the King's judges became the common law, the commune lay, as distinct from local customs. So we see that the customs were now giving rise to something of a more substantive framework. Now, where there was no general custom, the decision of these judges came to form the new law. Now, the development of the common law was linked to procedure, and action could only be brought in these courts by obtaining, meaning purchasing, a writ, which was a document carrying the royal seal that was in effect an order of the sovereign commanding the performance of some act. Now, if there was no writ to cover your precise problem, unfortunately, it was very difficult for the courts to listen to you. So, no right could be recognized in the common law unless a writ existed that provided a remedy for its breach. Now, the effect of this was a rigid legal system, which of course got to the point where it caused considerable hardship in respect of many individual litigants. Now, in response to this, a practice grew of persons petitioning the king. So they would go to the king directly because they would consider the king the fountain of justice. And they would go to the king for justice in individual cases. Now, the petitions were dealt with, of course, by the chancellor, who in that period was a man of the church and who was regarded as the conscience of the king. Now, in due course, a formal procedure for the petitions, of course, also evolved and developed, and this culminated in a court of chancery, so chancery of the chancellor, and this was presided over by the Lord Chancellor, who applied a system of rules known as equity rather than the common law of the common courts, the ordinary courts. So what you have then is you would have these courts which, if you had a writ, so if you had a problem, if you had an issue in law, you would have to go and purchase a writ, which would, of course, that may be a Freudian slip there, because generally it used to be rich people who used to be able to avail themselves of this. But you would have to get your writ, and then, of course, you take it to the common law court. The problem, of course, was that you may have a problem where there is no writ. A classic example is a situation where in the land law arena, where as land law principles developed, you had a situation where, for example, the common law only recognized the legal owner, the person on the title, as being able to deal with the land, as being the owner of the land. So, for example, when persons were going off to the Crusades and they left their land with somebody else by transferring it in that person's name, the problem then would be when they came back from the Crusades and they said, well, can you transfer my land back to me? If the person whose name was on the title now, in whose name they had transferred it, decided they wouldn't, they could not get relief from the common law court because there was no writ for something like that. What then, of course, developed in order to address these kind of problems, which clearly required some kind of equitable response, was, of course, the Court of Chancery. So what we will now look at or turn to is how equity has developed. Now, when you look at the Court of Chancery, or the Court of Conscience, it was effective in remedying injustices. The court developed procedures which were separate from those of the common law courts, and it also accepted the operation of its own precedent. Now, judges dealing in equity in their normal judicial discretion dealt with it in such a manner where there was free discretion of that particular judge. Now, the procedure here also became important, and the litigant had to be sure of the classification of the rule he sought to have applied in order to bring his action in the right court. So what is it you're looking for? If you're seeking some sort of equitable remedy, you need to go to the Court of Chancery. If you're seeking the sole common law remedy of damages, you're going to need to go to, of course, the common law court. Now, the Court of Equity became a set of rules almost as precise as those of the common law. And where you look at certain maxims of equity, these are rules of equity, they also developed as the equitable jurisdiction became a bit more prolific. Now, one of the equitable maxims, of course, is that where you see a situation where there's a conflict between the two rules, then equity will prevail. And the maxim, of course, is where law and equity conflict, equity prevails. It really means where the rules of the common law and the rules of equity conflict, then the rules of equity will prevail. So where, for example, you have a legal owner of a piece of land, so let's say I give you money to buy property in your name on the understanding that it belongs to me, but for some legal reason I want to buy it in your name. Well, the issue is that you are the legal owner, but because of the understanding we have and the fact that I put the money up, equity recognizes me as the owner. It means, therefore, that where there is a conflict between who is the owner of the land, you the legal owner, or I the equitable owner, where the rules conflict, the law will say I am the owner. Because I am the equitable owner, I will prevail. Now, all of this came to a head, of course, by the late 19th century with the Judicature Acts of 1873 to 1875, where it talks about the two streams now run into one. Because the Judicature Acts of 1873 to 1875 had put an end to the division of the courts and instead charged the courts with applying both the common law and equitable principles being applicable in the same courts. Now, the rules of equity were equally as important as those of the common law in resolving disputes that may be viewed as just or unjust. There are, however, notable distinctions between the two. When you look at the common law rules and the equitable rules, there are some points that you need to take on board. The common law rules are available to plaintiffs as a matter of right. For example, damages for a breach of a warranty of a contract. Equitable remedies are discretionary as they are subject to some general conditions of availability. For example, there is no absolute right to specific performance of a contract, specific performance, of course, being an equitable remedy. Equity is governed by general principles, and so if it is that you fall foul of those principles, you may not get equitable relief. This, of course, would not affect your common law remedy of damages. So say, for example, you don't meet an equitable principle, you may fall foul of not getting, for example, specific performance. So there's an equitable principle which says, he who comes to equity must come with clean hands. If it is that you have come with unclean hands, meaning you have done something wrong, but you are seeking an equitable remedy, then the court may not find in your favor. So that is one of the distinctions, of course, when you're looking at the common law and equity. Another distinction we will look at before the break is the distinction between common law and statute law. Now, when we talk about the common law, we can talk about the common law as a system of law distinct from, say, civil law, as in civil law jurisdictions like Germany and France, for example. But common law has another meaning. You can talk about the common law versus statute law. So common law is synonymous with case law. So common law can be used to denote law that is not the result of legislation. Rather, it is applied by the courts and developed through a system of precedent. And this is where you look at this whole idea of the judicial precedents being built. Now, when you look at it, it is often argued that the common law is a tradition of judicial responsibility and a barrier to arbitrary decision making. This, of course, was raised by Ronald Dworkin in his Law of the Empire, and he argues that judges basically evolve the law out of existing principles and constructive interpretation of existing sources. Some commentators, however, hold the view that judges create law, but this is something for you to think about. What do you think? Now, statute law is created by Parliament, and since Parliament is sovereign in the lawmaking process, then of course it can override judicial decisions. Now, we will of course look at when we look at do judges make law? This is something that you have to consider, because we see that this is a statement that is made, but is it true? You need to know how far that statement is correct. When you look at judge-made law, as it is called, it usually will be the precedents that have been set. But make no mistake about it, if the judges do something that the legislature is not happy with, the legislature will address it. And a case in point is a case called Burma Oil and Lord Advocate. I'm going to leave you with that whilst we go into a short break, and will return in order to complete the final segment of this law session.